Welcome to EMBARGOED, intelligent talk about sanctions, export controls, and all things international trade for normal human beings and trade nerds alike. I'm one of your hosts, Tim O'Toole, and with me today, I'm very excited to have two guest hosts, Laura Louca, who is a trade lawyer in Berlin, and Caroline Watson, who works with me at Miller Chevalier. And today we're going to have a conversation about EU and the U.S. sanctions, and really talk about. We're going to focus on what has happened in the last 18 months with respect to Russia and kind of the period of really unprecedented coordination. But also, at the same time, there are many similarities between the sanctions. There are also many differences. And so why don't we start by talking a little bit about, to set the scene, let's talk about the background. And so, Laura, I know the EU has kind of gone through, and the member states have gone through a time of unprecedented growth and coordination with respect to sanctions. Why don't you talk about the pre-February 2022 landscape in the EU with respect to sanctions, and just describe a little bit about what EU sanctions authorities were like in that time period?
Yeah, happy to. So, in comparison to the US, I think these Russian sanctions are the most comprehensive that we ever had. We did have the Iran sanctions in the past. We had Russian sanctions since 2014, and we had North Korea sanctions and so on. But none of those sanctions in the past have ever been as comprehensive as the sanctions are now. And so not only it's not only a precedent for the EU legislator, it's also a very new scenario for all the economic operators and the local authorities that have to deal with all the applications and so on. So yeah, I think we're a few years behind the US what that's concerned, but we are catching up. So.
Well, and in terms of catching up, I mean, I think there is kind of one big hurdle that the EU has that the US really doesn't. And what I'm thinking of there is, can you talk a little bit about how the sanctions authorities work with respect to both kind of policy, but then also enforcement? Because my understanding is while there's maybe one big policy group at the EU level, there are 30 different enforcers at the member state level.
Yeah, and that's exactly the issue. You have the EU legislator, and they're the ones who are implementing the sanctions regulations, and they're deciding about them. And with the Russian sanctions, we have seen those coming up almost every 2 weeks. But the enforcement is up to the member states. And so some member states have been confronted with sanctions regulations in the past because, let's say, with the Iran sanctions, Germany was already impacted largely by them, especially some major companies. But other countries did not have any contact with with such regulations in the past. So they did have to figure out, in German we say they have to figure out the wheel from the beginning. So they have to invent the wheel. So yeah, and this is a matter, especially what the penalties are concerned and so on. Every member state is responsible for enforcing the sanctions and putting on some penalties. And there you see a big gap between the different countries, not only on the level of the penalties, whether it's administrative proceedings or criminal penalties and so on, but also on the willingness to implement such penalties, and also on the capacities. Not every country was prepared to have an authority with, let's say, I don't know, 50 state attorneys that will follow up with such cases. So we do see a big backlog in many of these countries.
And my understanding too, I was actually in Germany with you in spring of 2022, and when the sanctions regulations were sanctions authorities were kind of just getting started in Germany and elsewhere, and there were even questions, not only about providing guidance, but who would provide the guidance. And there were, in Germany, but I think in many of the EU member states, it wasn't clear who was going to provide it, and then sometimes guidance was provided and then it was revoked, and conflicting guidance was provided. Can you talk a little bit about that?
I'm not going to name the name of the country because I don't want to trash talk any other European countries. But I've heard about one country where the authorities recommend of going to the police if you need advice on the sanctions. And I've heard about other countries where the lawyers go to the authorities and say, hey, we have this unclear situation. Can you clarify it for us? And the authorities say, please consult a lawyer. And you're like, but I am a lawyer and I'm asking you because you're the authority. So, it. I think you have so many issues on different levels. On the one hand, you have this legislation which came pretty fast, and there were mistakes in the wording, in the translation, or it was unclear how to understand it. So the authorities had to suddenly understand what the EU legislator wanted to tell them, and give guidance on that to the economic operators, to the entities. But on the other hand, some authorities did try to do so. For example, in Germany, they did make a list of FAQs, but often those FAQs contradicted the FAQs of the Commission. So, which guidance do you follow? They have tried to adopt them, to adapt the questions that were contradicting each other. But still, there are some remaining issues where you're not sure which FAQs are decisive. And we have experienced that at some point the authorities, whereas at the beginning they were trying to help and they were trying to give clear answers and answer as soon as possible, at some point they would just say, you know what, this is something that you can argue, but at the end of the day, we are not the prosecutor, so we would recommend you um, to distance from this transaction. So, um, you know, yes, you're not the prosecutor, but at the end of the day, if you're not able to tell me what to do, and the prosecutors obviously don't know the law as well as those export control and sanctions authorities, because the prosecutors have been confronted with this bunch of cases for the first time in their life, then who else is going to help?
Right.
Unless we go to court, but we want to avoid that, right? So, yeah.
Yep. No, that's got to be just a really difficult situation for companies that are just trying to figure out what their obligations are to comply.
Yeah.
Caroline, why don't we turn a little bit to the pre-2022 landscape? And here we'll talk about the U.S. And the U.S. doesn't have these sorts of internal coordination problems because, for the most part, sanctions policy from the U.S. is set at the federal level, and while states sometimes have these laws, they're really not all that important, to be quite honest. It's really all about OFAC. But the question that I wanted to kind of throw over to you is, in terms of all about OFAC, pre-February 2022, I think if you talked to EU lawyers and EU sanctions authorities, I think their view on the OFAC and U.S. sanctions authorities would be that it was very one-sided. OFAC basically just figured out sanctions policy with respect to, say, Iran, including secondary sanctions on Iran that would govern, German to French transactions, according to OFAC, even if they had no U.S. nexus. Can you talk a little bit about kind of where things were with respect to the U.S. and coordination with the allies prior to the implementation of the Russian sanctions?
Absolutely. So prior to 2022, most of the U.S. sanctions programs were very unilateral. U.S. had foreign policy objectives and pursued those with the sanctions programs, regardless of the policies of other allied countries, especially even in the EU. So some of the big programs relating to Cuba, one of the longest standing ones, Iran, Venezuela, those were very unique to the United States, and quite a departure from how the EU has treated those jurisdictions. I believe there's even been mounting conflict in some of those areas where the EU, and Laura can probably speak more to this, the EU even opposed some U.S. sanctions in those countries with blocking statutes. So it puts a lot of international companies in quite a conundrum. How do you comply with U.S. sanctions programs versus EU blocking statutes? Um, and there's just a real difficulty there in navigating any sort of business involving those jurisdictions. And that all changed in 2022 with the coordination, I would say, not just in the issuance of sanctions, but also in the enforcement. The US and the EU have really been trying to achieve the same objectives here. So while there's some key differences in the programs that we'll be going through today, I'm sure, uh, generally speaking, the two sides have really tried to come together and consult before issuing sanctions and before pursuing enforcement that might impact companies with operations in the two.
Yeah, that's a really good segue, Caroline. So I think it is fair to say that what we have seen since February 2022 is really an unprecedented level of coordination between the EU and the US. Why don't you just follow up and start talking a little bit about that, and then we'll turn it over to Laura to add some context from the EU side.
Yeah, absolutely. So there's a couple really big examples of the level of coordination that's been happening since 2022, starting with the enforcement task force that was created between the US and the EU that is unprecedented in regard to sanctions. And while the impact of that task force may not be as effective as intended, there's opportunity there for it to increase. Then we have a couple other examples. The price cap sanctions has been a level of coordination and cooperation between the US and EU in a very difficult area regarding energy. It impacts both sides significantly, and they were able to come to an agreement on that and have an effective coordinated policy there. And even the way that, or the tools that are being used for this coordination, the G7 is being used as a forum to meet and coordinate on sanctions policy in ways that it never was before. So those are just a few of the examples that come to mind with regard to the coordination there.
And Laura, why don't you talk a little bit about the coordination from the EU side? I mean, from the US side, I think one of the things that just from an outsider observing, it does seem like a number of the member states and the EU generally are kind of building a sanctions infrastructure that looks a lot like what we saw OFAC build, probably 15 years or so ago, where they're really starting to build guidance mechanisms. You've talked about it a little already with some of the hiccups, but it really does seem like these institutions are maturing and coordinating with the US and with them among themselves and with the UK in a way that we've never really seen before in the sanctions context.
Yeah, definitely. I mean, as Caroline mentioned before, not only did we not have the level of US sanctions previously, but we even blocked some of them. But now with the enforcement task force, I think in total they were having over 58 billion assets frozen and seized just because the information exchange is working way better. And these are maybe numbers or information that you won't see made public as much, but I do think that in the background there is more information and exchange and experience exchange that we haven't seen in the past, especially what the experience is concerned, because the EU authorities have not been as experienced in investigating foreign assets and foreign individuals. So I think they have been learning a lot from the US colleagues. And then you mentioned the price cap. This is also something I think we just followed more or less the US lead, and you can even see that in the regulation, because I think the currency for the price cap is in US dollars. So we just copy pasted it more or less, which is fine, because now if we have some questions on how to understand the EU law, we can just ask our US colleagues how they understand theirs, and then we can we could try and figure it out if it would be similar in the EU.
If you find any U.S. colleagues who really understand the price caps, let us know, because they've really been kind of a mystery to a lot of people. We had a whole podcast devoted to the podcast or to the price caps when they came out, but they still are very opaque, and so
Yeah.
but they do trace back to OFAC. So I guess we're the ones who are supposed to roll up our sleeves and figure them out. But I can tell you that from my end, it's not very easy. Sorry to interrupt.
Yeah, no worries. Now, you know what? I actually had a client asking about the price cap again today. But other than that, I think most cases, or the cases that, or the clients interested in the price cap, may be less and less now because the wind down period is over. So, I think most of them have already adopted their businesses, and those who haven't, well, yeah, they're still trying to understand it, as you said. But then you also mentioned the G7, and I think that was a real big milestone in the whole process because if you think about it, it's not just the US and the EU member states and maybe also the UK that were meeting and then coordinating Russian sanctions, but it was also other third countries. I mean, the G7 took part in Japan, so though it was, you could see that it was more or less on a, let's say, more international Western level, and not so much just two authorities in the background or in the back office trying to figure out what to do with the Russian sanctions. So yeah, that's
That's a good recap. And I wanted to start with kind of the growth and the coordination, because I think that is one of the big stories of the Russian sanctions program over the last 18 months. But what we're going to talk about now, probably for the rest of the podcast, is some of the key differences between the U.S. and EU, because in other sanctions programs, it's almost all key differences. But here there's a lot of coordination, but there are still areas where the US and the EU diverge. And so we've talked a little bit already about one of them, which is, you have the centralized US system with OFAC. You've got the EU sanctions that are left to the national governments in terms of, or there's a division where you've got the EU Commission issuing sanctions policy, but then the local governments have to sort it out. So why don't we move on to the question of jurisdiction? Because I know that in the EU for sure, and really in the rest of the world outside the US, there's been a lot of controversy over the last 10 years or so about the broad way that OFAC and the U.S. exercise jurisdiction over transactions that often seem to have little or nothing to do with the U.S. Why don't we start with Caroline on the question of U.S. jurisdiction and OFAC's view of U.S. jurisdiction, and then we'll turn it over to you, Laura, to talk about the EU jurisdictional theories and how the EU exercises jurisdiction and kind of where that stands today.
Yeah, the way that the U.S. exercises jurisdiction here has not really changed with regard to the Russia sanctions. The U.S. has traditionally exerted legal jurisdiction under sanctions law extraterritorially and very aggressively. It does so when it finds, or OFAC finds, that there is some kind of U.S. nexus involved in whatever transaction or dealing that it's examining. And this is, a U.S. nexus is broadly interpreted to include situations that might not be anticipated by a lot of businesses. So for example, you can have U.S. persons involved working at a non-U.S. company, and their involvement in a transaction could be interpreted as a kind of U.S. nexus that would lend jurisdiction over the transaction. The use of U.S. Currency is often found to be a basis for exercising jurisdiction over a transaction. And so, even in situations where parties might not expect to suddenly become subject to U.S. law, they find themselves in that situation. And that's just legal jurisdiction. The U.S. also exercises secondary sanctions authority in situations where there is no U.S. nexus. It's not a legal jurisdiction. It's just a more of a foreign policy that can be used, and it's a very aggressive one in comparison, I think.
Yeah, and I think when I was talking about controversy, that's mostly what I had in mind was the pure secondary sanctions, where everyone admits the U.S. has no jurisdiction, and yet it still imposes penalties on the parties to transactions that don't have any connection with the U.S. under this fiction that it's not imposing a penalty on the party by putting them on the SDN list. It's just telling U.S. persons that they can't deal with them anymore, and so therefore OFAC has jurisdiction because they can tell U.S. persons what to do. And then also in the Cuba realm, where the U.S. sanctions apply not only to U.S. companies but to U.S. owned companies that are overseas, which I think created a lot of the controversy in Europe. So Laura, with the U.S. having this broad jurisdictional theory that the EU has from time to time criticized, tell us a little bit about the evolution of EU jurisdiction in connection with the Russia sanctions, because my understanding is that the EU has been at least slowly moving a little toward the U.S. broad theory of jurisdiction.
Yeah, I mean, it's really interesting. For years now, we have been criticizing the U.S. secondary sanctions and they're a violation of international law and so on, and, releasing the blocking statute, and even on a national level, Germany has a law which is basically pretty similar to the EU blocking statute. But now with the Russian sanctions, public international law is not so much of an issue anymore. We don't call them secondary sanctions, but in the basis of it, they're pretty much the same. So the EU has, for example, sanctioned Iranian companies who have been dealing with Russia, especially in the drone section, claiming that they have been supporting the Russian invasion into Ukraine by delivering those products to them. So we have sanctioned them. And with the 11th sanctions package, the EU legislator has also kind of, threatened countries that keep doing businesses with Russia, or at least companies who keep doing businesses with Russia, will be sanctioned as well. That list is still empty, so it's an annex, but there's no name in it. If you separate the Iran companies that have been sanctioned, but they have moved forward to that step, and then who knows, at some point that list will be filled up. But we don't call them secondary sanctions, so it's completely different.
It must be fine, exactly.
Yeah, it's fine.
They're not secondary sanctions. I don't know what you're talking about.
Yeah.
All right. So on jurisdiction, it sounds like we've got a little bit of convergence, but still, I think the EU is kind of moving slowly into this area. What about licensing? So licensing. Why don't you talk a little bit about licensing in the U.S., Caroline, with respect to OFAC? If you want to do something that is at least facially prohibited by the sanctions, talk a little bit about the OFAC procedure. And before you do, I do want to give a shout out to OFAC on Russia licensing. They have devoted significant resources, and the licensing at OFAC has gotten substantially better and is fast and responsive in a way that we haven't seen in some of the other programs. I think it's about resources, but when OFAC does well, we should be sure to note that on this podcast, because sometimes when they don't do well, we know that as well. So why don't you tell us a little bit about licensing, Caroline?
Absolutely. And, just as we were very busy when those sanctions came out, I'm sure OFAC was as well, and they did amazing work in handling that volume. With respect to licensing, being a very centralized system really helps. All the licensing goes through OFAC. So the policies and the licensing tends to be very uniform, very consistent, generally speaking. Of course, it's based on foreign policy, so there's some variance there. OFAC uses general licenses quite frequently, and those general licenses are issued and renewed on a regular basis as well. And so that is something that a lot of companies are able to avail themselves to, and able to continue doing the kind of business that the U.S. thinks is not a threat in any way to national security interests. So there's various licenses relating to humanitarian interests, relating to certain kinds of transactions that the U.S. would encourage. And then there's specific licenses where parties that need to conduct a transaction can apply to OFAC for a license relating to their specific situation and justify why that should be issued to OFAC. it's not a guaranteed issuance, but if OFAC finds it consistent with U.S. policy, they might grant that. And with Russia, they've been doing so fairly relatively quickly in certain situations. I think we'll probably be getting to the divestment issues and how OFAC has been very proactive and issuing those kinds of licensing.
Yeah, no, I think divestment is a topic unto itself. But on the licenses, I will say one of the hallmarks, I think, of how OFAC has matured over the years is that they're, in my view, they do a very good job of anticipating where a general license will be needed when they're coming out with prohibitions, much better than they used to. And so the general licenses go into place at the same time the prohibitions go into place, so if there's a wind down license, but not just a wind down license, there are other types of licenses where they anticipate here is the sort of disruption that this prohibition will cause, and we don't want it to cause this sort of disruption. So we're going to have a general license that's going to carve out the areas that we're worried about disruption, and they do it at the beginning so that they avoid what in the past was sometimes the chaos that was caused by a SDN designation where they didn't realize that it was going to affect particular types of transactions. And so, 3 months, 6 months later, you'd come out with this new general license that would try and address that. But they've been very good, in my view, at anticipating it beforehand and getting the general licenses out at the same time. And the one area of licensing I did want you to comment on as well. So my understanding is that to get a specific license, you have to have a U.S. connection. And if you don't have a U.S. connection, you can ask for a request for interpretive guidance. So if essentially I'm a non-U.S. party and I don't want to engage in a U.S. transaction, but I want to make sure I'm not going to get secondary sanctions, but I don't have any U.S. connection. Talk a little bit about the requests for interpretive guidance and how effective those are.
Absolutely. So when there is no U.S. legal jurisdiction because there's no U.S. nexus, a lot of parties may still be hesitant because of some perceived risk of secondary sanctions, and they want to make sure that everything is going to be okay with U.S. authorities. So in that situation, they might submit a request for guidance to OFAC saying, here is the transaction that we want to do. We don't think that there's legal jurisdiction, but we still just wanted to check with you to make sure that you're not going to be, against this kind of transaction, that you wouldn't see it as posing a risk of secondary sanctions. And it can be, it could take a little while to get a response from OFAC to those kinds of submissions. Sometimes OFAC might be responsive if it finds that it's particularly that it warrants a fast response. I would think that in situations where it's a humanitarian related transaction, OFAC might be motivated to respond relatively quickly. Other ones it might find less crucial in its own view based on the lack of a U.S. connection.
Yeah,
it's going to prioritize
those guidance requests. I agree with you. They're very unpredictable in terms of if and when you'll get a response from OFAC. Sometimes you can get a response in a day or two, and a helpful one, and sometimes you're sitting there a few years later without having had anything. And sometimes people call that a comfort letter. I mean, these comfort letters come, but they do not come very often or predictably. At least it's been my observation. So, Laura, why don't you tell us a little bit about EU licensing policy? Because I know it's got to be more complicated with all the member states out there.
Yeah, again, it depends. There are general licenses on an EU level. For example, in export control of dual-use goods, the EU has issued general licenses. And then, in addition to that, member states can also issue general licenses in specific areas. But regarding the Russian sanctions, the EU has been very reluctant regarding general licenses, whereas the US, as I understood, has issued a lot of them. But there have been some, let's say, prohibition exceptions regarding humanitarian export of goods for humanitarian purposes, or export of goods or provision of certain services, for example, subsidiaries of EU companies. But these exceptions fall under a specific licensing procedure, which is up to the member state. So you have to go to your national authority to apply for those licenses, and all these leads to a backlog of applications. It used to be in Germany that it only took about 6 to 8 weeks to get a license, with some exceptions where you could take years, but those were like, anything related to China, military, and so on. But for the normal, let's say normal dual use goods, you would wait approximately 6 weeks to 8 weeks. Now, the first thing they tell you on the phone when you call them is like, please be aware that it may take at least 6 months. In some cases, we applied for a license a year ago and we have received the response, hi, we are now getting up to your application. Is it still relevant, or can we just delete it? So,
I think they borrowed that tactic from OFAC, because we have things that are pending for a long time, and then we get this like, we know it's been a long time and you haven't heard from us. Is this still relevant? Because if not, let us know, or we're going to just delete your application in 10 days. I mean, I think that OFAC like tries to, if it sits on stuff long enough, it feels like it moots it out. Exactly.
Yeah, so you see, we're not only copying your regulations, we're also copying the tactics. So,
exactly.
But jokes
coordination,
aside,
right?
Yeah, coordination. Thanks to how things can go more smoothly, at least for the authorities. But jokes aside, I must say that the authorities have just been, where they had like 20 applications maybe a week. Now they had several hundred applications a week.
Right.
And they don't have enough capacities. They don't have enough personnel to deal with these applications. And there was like a public plea by the president of the National Export Control Authority in Germany, where he said, we are trying to do our best. We are trying to respond to every license, but you would help us if sometimes you would just read the regulation. Some applications are so unnecessary. Some questions are just unnecessary. So we are doing our best, but please just don't bombard us with all these questions if it's just a matter of reading the letter of the law and then clarifying it. So yeah, they are doing their best, and in some other EU member states, they have been confronted with these license proceedings for the first time, especially what sanctions regulations are concerned, because their industry was not relevant to such regulations in the past. So they had to, implement a new system, sometimes create a new authority. So the know-how wasn't really there. And I must say, for that, a lot of member states have catched up pretty quickly. They're doing their best, I hope, even though it's not always the optimum result.
Yeah. I mean, I think that is something that we just all have to keep in mind. And I know that it gets frustrating for clients who want an answer really quickly. And again, I think OFAC has done a really admirable job of moving quickly on the Russian applications, at least the ones that I've seen. But they are so slammed by all of these applications. And I think one of the things that OFAC has done, and it's my understanding, is that they've moved a lot of people over to the Russia desk and away from some of the other programs. So we are seeing, even greater delays in some of the other programs than we saw before February 2022. But the resources are being moved to Russia, but still the volume is just overwhelming in the States. And I mean, you do see a lot of, and I think, to the extent that the head of the German export agency was talking about reading the regulations, I also think, at least if it's like the U.S., there's also a lot of client risk aversion because of the high-profile nature of the Russia sanctions. So if there's even the slightest bit of ambiguity, even though we would advise that this is likely permitted by the regulations, but there's a slight bit of ambiguity, we'll have clients who want to go in for a license because they're not comfortable with any ambiguity at this point, and ambiguity is almost inevitable. And so I think that a lot of these license applications, at least from the U.S. side that we see, are clients who we know what the right answer is, but they don't want to take it for granted if there's any ambiguity, so they just go in and ask for a license, which increases the volume, unfortunately.
Yeah, exactly. And I mean, it's what you said. They have moved, I think, a lot of personnel from the other licensing procedures to the Russian sanctions matters. What the German National Authority has done is that they have simplified the procedures of licensing in some other areas irrelevant to the Russian sanctions. And the hope is that this will create capacities, more capacities for the personnel to deal with the Russian sanctions applications. And they have implemented a hotline where you can call them, although at some point I think you don't reach anybody anymore because the phone is probably ringing every day, all the time. But they have tried to do so at the beginning at least, and they have implemented a Russian sanctions email account where you can direct them with just a simple question without having to go through the whole license application process. So yeah, there have been some steps.
Yeah, no, I think it's really admirable, and we've noticed. If OFAC was wondering, we've definitely noticed that they have upped their game with respect to the Russian licensing. All right, so let's turn to another topic that there's probably some differences, although it's been a high-profile topic, and has been a topic that has been the subject of a lot of coordination as well. So both in the U.S. and in the EU, I think at the political level, there's a lot of talk about essentially taking Russian assets or assets of sanctioned parties and using them to rebuild Ukraine. Um, and it's a good and understandable talking point in the sense that this is from both sides of the Atlantic viewed as a war of aggression by Russia against Ukraine. And since the point of the sanctions is to impose deterrence on that and to impose penalties on that, it's understandable that one of the ways that the hopes is that the U.S. and the EU will use any assets that are taken through the sanctions to help rebuild Ukraine to essentially repay the costs of that aggression. It sounds good. The problem is that sanctions, at least on the U.S. side, and Laura, you can talk about it from the EU side, you're not taking assets when you sanction someone. You're freezing. And taking assets is different than freezing them by a lot on the U.S. side. Caroline, why don't you talk a little bit about the U.S. side and the differences between a blocking sanction, which just freezes assets, and actually what it takes to get the assets so that you can actually transfer them to the Ukraine?
Yeah, imposing the blocking sanctions, which is the most commonly used tool by OFAC, just requires OFAC to justify the imposition of sanctions on whatever basis they have or of authority they have. So if they are authorized to impose sanctions on Russian parties involved in certain sectors of the Russian economy, they can do so, basing that on that party's participation there. But expropriation or seizing those assets is a much higher bar for them to prove. That would involve taking, first of all, that would have to involve some kind of alleged criminal activity on the part of the sanctioned person. And then the U.S. government would have to take them to court to obtain warrants or authorization to be able to seize those assets. And so without a alleged crime, there's not an ability to pursue that option at the moment, and so it's not very commonly done, and it is a very difficult standard for them to meet.
Yeah, just to flesh that out a little bit. So, what we see on the sanction side is someone will be put on the SDN list and their assets will be frozen, at least with respect to any U.S. connected assets. That happens with no process whatsoever. I mean, you find out about it because OFAC issues an email saying the following persons have been added to the sanctions list. And then they sometimes have a press release that describes, at least in part, why they're adding them to the sanctions list. To take those assets, not only do you need to do the seizure process that you talked about, Caroline, you still also need to go through a forfeiture process, which is a contested judicial proceeding in most instances, where you actually get a court to rule that the assets are somehow connected to crime. I mean, there's a whole forfeiture statute that describes the standards, but to boil it, to make it simple, they've got to be, as you said, connected to a crime. And so that's a real, difficult and long process, as opposed to the blocking, which is just, you snap your fingers and it's done. Now, there's a lot of work that goes on behind the scenes for blocking, but you don't see it. It just happens from the outside. Laura, why don't you talk a little bit about, did you want to say something?
I was just going to say one of the few instances, I think, in the Russia context that we've seen some activity here on the U.S. side has actually fallen under the export controls that are related to the sanctions, where a crime may be a little easier to prove in that instance. And so they've gone after a certain oligarch's property, specifically aircraft, on that basis.
No, that's exactly right. And they've come up with new theories to do it. So not new theories. I mean, General Prohibition 10 has been around for a long time, and that's the part of the U.S. export controls laws that says that if any item is exported unlawfully, it is prohibited to deal with that item. And so what they've done with the aircraft is they've made any aircraft that is exported to Russia, meaning any aircraft that is flown into Russia or transferred within Russia by flown within Russia, if it's U.S. origin, if it's subject to the EAR, it is now requires a license, and nobody's getting licenses to do this. So those aircraft, and OFAC, or not OFAC, but BIS sees those on the radar and sees that those aircraft have either gone into Russia without a license or are moving around Russia without a license. They put them on a list. And then anybody who touches those aircraft, and those aircraft themselves, are the proceeds of a sanctions or an export controls violation, and become potentially criminal if you know it. And the reason that they publish the list is so that they can say that anybody who touches that aircraft, who deals with that aircraft, is on notice that it has been the product of an export controls violation, and then it becomes a crime to deal with it, and then that is used as a basis to seize various aircrafts. So it's a new theory that I'd never seen before this all happened, but it is one that they are trying to use to kind of bring this within the scope of the seizure and forfeiture laws in a way that, just putting somebody on the list and saying that they're an oligarch is easy to do from a sanctions perspective, because there's a executive order from the president, and also, CATSA allows for putting people on the list for quote unquote being oligarchs, but being an oligarch is not a crime. And so just putting somebody on an oligarch's list doesn't necessarily give you much of a basis to seize the assets. So you're exactly right, Caroline. They're coming up with new ones, and they mostly relate to the export controls laws. So Laura, why don't we turn it over to you to talk about how this whole process is working in the EU? Because I know there's a lot of coordination on trying to get various Russian assets and use them to rebuild Ukraine, but how's it working over there?
Yeah, I mean, we haven't had any experience with this in the EU. This discussion has not been, the EU hasn't been discussing this with previous sanctions. It's the first time that they have really been discussing this so intensively. And I feel like sometimes it is less of a legal argument that has been going on and more of a political argument. But as you said, the threshold of becoming listed is really low. If you see at the reasoning and the listings in the EU, at least they have a reasoning behind it. It's as simple as he's related to oligarch XYZ. But that in itself is not a crime. So being listed does not mean that you participated in a crime. You might have, but it's not a proof of that. So, for now, we don't have a procedure that would be constitutional and where we could use those assets for rebuilding Ukraine. The criminal laws on a national level, they do see the forfeiture of assets that have been used in a crime. But again, this is on a national level and not an EU level. And as I said, you have to prove that they have been part of a crime. So you would have to go through a procedure that proves that that specific oligarch was participating in a specific crime and those assets were part of that. Other than that, I don't see this coming anytime soon. I must say, the politicians have been using this as it's good to hear. Yeah, let's use the Russian money to rebuild Ukraine, and but it's more or less, I think, a wishful thinking. let's see if it develops in the next months or years. But until now, there hasn't been a real substantive discussion on how this procedure should look.
Yeah, I mean, it sounds like it's pretty similar here. I mean, we've got some developed procedures, and there's been some at the margins, and particularly, as Caroline mentioned, with respect to various aircraft attempt to get assets, but it's not been anywhere near on the scope that it's been discussed. I mean, because, rebuilding Ukraine is going to cost a lot of money, and I don't think that there's been, they've been able to go after anywhere near the sorts of assets that you would need to really get that started, because it is a lot harder to actually get title to the assets than it is to just impose sanctions and block them. It sounds like it's the same in the EU.
And you would have to, you'd have to give the persons influenced by those, whose assets have been frozen. You would have to give them the opportunity to defend themselves,
Yep.
to argue that the assets have been frozen with no reason, and all this procedure would take up new capacities, new authorities, new
Yep.
procedures. So
Yep.
I think let's deal with the issues that we have now, and then we'll see after that.
Well, on a similar level, I mean, we've been talking about this already a little bit. When someone is put onto the list, there really is no process beforehand, usually, at least in the U.S. side. What about after they're on the list? I mean, what's the process in the EU law for trying to get off the list, and talk about who deals with those procedures and how well established they are?
The process of becoming on the list is up to the EU legislator, and the bar, as I said, is pretty low. I think before the Russian sanctions of 2022, I think there might have been like 200 people on the list for Russian sanctions, and I think now it's over 1,000. But there is a procedure in place where you can get delisted. You can submit an application where you can basically you have to prove that the delisting was with no reasoning, that there wasn't sufficient evidence for the listing, and also some procedural errors. You can argue that there was not enough, you didn't have the opportunity to defend yourselves, or that there were some issues in the proceedings of the listing. I think there was one successful delisting for the Russian sanctions, for the current Russian sanctions. And other than that, there have been some successful cases with Iran sanctions, and I think also with the terrorist list. This is decided by the European Court. And it takes, it can take a few years. With the Russian sanctions, I think it only took a few months. With Iran sanctions, there were some cases where it took around 2 years, which I think is not as bad as one would expect it to be. And they also can claim damages for being sanctioned with no reasoning. So yeah, there is a proceeding in place. I think the chances of being successful are less than staying listed, but they do have the opportunity to go through that procedure.
And who do you go to? So do you go back to the EU Commission that listed you in the first place, or do you go to a court? Like who hears these?
Yeah, you go to the court. You go to the European Court of Justice. So and then you can apply for a delisting.
Got it. Well, Caroline, why don't you talk about the OFAC delisting process, because it is a little bit different, and I think it might be fair to say the odds are even more stacked against you.
Yeah, as compared to what Laura has described, the process on the U.S. side is not nearly as transparent, and generally doesn't involve going to the courts. Usually on the U.S. side, you can apply to OFAC to be delisted, and OFAC, says here, submit your petition for delisting, right here. But what happens after that is very unclear. These applications can take a very long time. They can take years to receive any kind of substantive response from OFAC, and with very little contact during that time. And the factors that OFAC might use or what might impact their decision on that can be somewhat unknown as well. And and a lot of this is because the standard for imposing sanctions is generally very deferential to OFAC in the first place. So a lot of it comes down to foreign policy.
Yeah.
As
Oh,
Laura
go ahead.
said, sorry, there's also, you can say there was a mistake in the facts, you don't have, the correct facts, and that kind of argument. But it still can take a long time to
Well, and
process. And
just go
sorry, go
ahead.
ahead.
No, go ahead.
I'm not aware of any ability, unlike on the EU side, to seek damages in that context either. You might get off the list, but what you've suffered is uh, not going to be addressed.
Right. Right. And I think OFAC tries to avoid the damages issue by, when property is blocked, the banks or whomever blocks the property is required to pay interest on whatever is blocked. And that is a way that, the argument is you're not being damaged because you're getting interest on your property and it remains your property. You just can't get it back until you get off the list. I mean, I just do want to emphasize something that Caroline just said in terms of the challenges with OFAC. I mean, in the EU, it sounds like you go to court, and so you have a new decision maker that's going to review whatever the listing was. With OFAC, it's technically called an application for reconsideration. So essentially, you go to OFAC and you have to say either you got it wrong or even if you got it right, the circumstances have changed. But it's OFAC that gets to decide whether OFAC was right, which is, as you can just from saying that, you can see that you're not going to win very often because you have to convince the decision maker that they messed up. And so, they do mess up, and sometimes they acknowledge that they messed up and take people off the list, but they're not very quick to do that, and it doesn't happen very often. And then you do have some right of judicial review, but it's very limited in the States because, OFAC is seen as a foreign policy agency, and the courts defer to the executive branch here on foreign policy issues. And so it's very, very hard to get a court to second guess OFAC, but it's, at least as hard to get OFAC to second guess itself. So it's very, as a practical matter, getting off these lists is pretty hard.
But I
Well,
must
why don't?
say,
Oh, go ahead. Yeah, go ahead.
just catching up on the foreign policy issue, because on the EU side, you can argue that there are factual reasons, there was a wrong assessment, but at the end of the day, the council does have a wide scope of judgment regarding the foreign policy issues, so they can say we are the experts on this, and we have a wide scope of judgment. So although the court can challenge all these arguments and they can review them and so on, it is still pretty hard to argue that the assessment of the EU legislator on the foreign policy issues, where they're supposed to be the experts, is wrong. But yeah, like I said, there have been some cases where people have been successful. So.
All right. Well, hopefully we can move to more of an EU system here in the States, because I think having the courts involved is a good thing. It's just, people don't like to admit they're wrong. So having somebody else look at it and decide whether they were wrong seems like a better system to me. But let's talk about another area that is tricky, and that is getting out of Russia. So since the beginning of the invasion, I think both on the U.S. and on the EU side, there has been a policy that companies, if they can get out of Russia, they should get out of Russia. But as we know, that is easier said than done quite often. So why don't I put it to you first, Laura? Just talk about EU policy with respect to divestment from Russia and some of the challenges that you've seen in that area.
Yeah, so in the EU, you have the first of all, I think many companies have decided with the beginning of the Russian sanctions that they want to withdraw from Russia. So they have been doing so even if they were not obliged to do so. If the assets of your company fall under some lists, so if they're sanctioned goods, and you do an asset deal, then you have to apply for an authorization basically to transfer those assets to your buyer. There have been some debates whether this also includes share deals. And there have been, again, we see the differences, EU and the US. In the EU, you have so many member states. So member states have been coming to different results. Germany has had a pretty clear position on this. They said share deals do not fall under it. Even although at the end of the day, the buyer still gets control over the same assets and the same products, but share deals don't fall under it because the wording of the regulation does not cover it. In Sweden, I think the authorities have not had a clear position yet. In Denmark, I believe I heard from a colleague that the authorities say, nope, share deals do fall under this authorization proceeding. You do need an authorization for those proceedings, but they have been, handing them out immediately. So, yeah, these are I think the basic framework of can I divest from Russia, and what do I have to do on a procedural level to do so? And then you have all the practical issues, how do I get the payment for the buyout? How do I get my products out of Russia? What do I have to pay to the Russian state to get my company sold and get at least a part of the price that I put on the sale? So yeah, at the end of the day, these proceedings have been dragging out for months most times.
Caroline, why don't you talk a little bit about the U.S. side and kind of the dynamic in the U.S. where the OFAC and the administration favor divestment, but there's some hurdles.
Yeah, they've definitely had a policy in favor of divestment and exiting the Russian market. However, there was a bit of a hiccup recently when the OFAC has issued a general license in the past that allows certain transactions with the Russian government, which is otherwise sanctioned, and the scope of that general license appeared to cover situations that might be implicated in divestment. So when a lot of companies started leaving Russia, the Russian government imposed some measures to make it more difficult to discourage divestment, and that included limiting recovery in those transactions to I think it's now about 50% of the value of those assets, and then also requiring the payment of what we call an exit tax. And that's a payment to the Russian government itself relating to the transaction, usually a certain percentage of that transaction. And whether that payment to the Russian government was authorized under the general license became a question for a lot of practitioners that were advising companies through this process. On its face, it seemed that this kind of situation would be covered, but then OFAC issued guidance to the contrary, explaining that the GL was not intended to cover those kinds of payments, and so companies really needed to analyze the situation to determine if a license was required for those payments. And that definitely threw a lot of companies for a loop in figuring out how to accomplish a divestment, which is already so difficult in the first place. As Laura mentioned, there's so many different sanctions compliance issues to consider in that situation. And so this just adds to that pile. Thankfully, in handling the situation, OFAC has been, in our experience, very swift in responding to applications seeking licensing or requesting guidance on this specific issue. And I think that speaks to their policy in favor of divestment in the first place. So they've definitely prioritized, sounds like similar to the EU situation you were describing, Laura, where companies trying to do this will receive generally the kind of help that they need in doing so. And I think that there's a similar situation on the export control side, which is definitely something that is tied to the U.S.-Russia sanctions, the high level of export controls. And in the regs now, it provides that while there's generally a policy of denial for export licensing in these situations involving exports to Russia, that when there's a situation of divestment involving companies from most jurisdictions, U.S. and EU, et cetera, there will be a policy in favor of granting that kind of a license application. And so I think that when these issues arise, thankfully, they're going to be easier to solve than ordinary because of that policy.
Yeah, I mean, just a couple of things to add. mostly for the sanctions nerds who are listening, because I mean that was a great description of the whole process. I mean, these are payments to the Central Bank of Russia, which is a prohibited but not sanctioned party under U.S. law, just to make it more complicated. And they're often quite big. And so on the one hand, you've got, the U.S. foreign policy of, no payments to Russian governmental entities like the Central Bank of Russia, because for policy reasons, the U.S. feels like that is an entity that will help Russia get access to currency that can then be used to fight the war. On the other hand, you have this policy of divestment where you're paying this money so that you can get out, and the U.S. is trying to encourage U.S. companies to get out of Russia. And so it really was this area that OFAC had this kind of, on the one hand, they don't like the payment. On the other hand, they want you to get out, and they've really tried to resolve that by favoring divestment, but exercising review over these payments so in the licensing context, so that they can make sure that the payment itself doesn't have any specific issues that otherwise make it, undesirable under U.S. law. So it's been a very complex area because of all of these kind of competing policy concerns.
And I think at the end we have to ask ourselves, what would the alternative be, right? Because, I mean, some companies left Russia or wanted to leave Russia due to moral reasons or political reasons, but some companies wanted to leave Russia because they couldn't send their products anymore. Everything was listed. So basically the business with the Russian subsidiary was, total unnecessary anymore. So what would the result be if they don't get the license from the authorities to get out of Russia? At the end of the day, they will just decide to leave the company there, free, just don't work with it anymore. But at the end of the day, the Russians will still get power or jurisdiction over that company if you don't operate it anymore. So, at least on the one hand, you want to divest and at least get some money for it. Otherwise, you will just leave it there and the result will be the same.
It's a great point. And the one thing that I would add to it, because this is one thing that I've thought about a lot in this context, is the Russians set up this exit tax precisely to try and keep companies there by forcing them to violate sanctions in order to leave, so that they would have to go ask for permission to do it. And I think the hope was that the agencies would be very slow in granting licenses, if they granted them at all, and might put them in the position where they just have to stay because they can't get a license to get out because they're sitting there waiting. I mean, and so the idea that the Russians came up with this precisely to put them in the dilemma that we're now in, ought to factor into the idea that perhaps maybe the agencies ought to be thinking two steps ahead of that and not let essentially any manipulation of sanctions rules go on by forcing these payments that are going to keep companies there forever, because that's the whole point, right? The Russians have been trying to come up with the 50% limit on what you can recover, and now this exit tax, it's try and keep Western companies in Russia doing business there. And so if the sanctions are that manipulable, ultimately you won't be able to accomplish your policy goals. And so that was when the whole exit tax issue arose. It kind of arose out of the blue in the U.S. because the assumption was that this would be covered by one of the general licenses. And then when OFAC said, no, it's not, there was a lot of thinking going on about how this is going to keep, and I think it has, at least for a short time, because the licensing has been fast. It's kept companies in, but some companies may decide that it's too expensive to apply for a license, and it's just easier to stay. And do we really want them staying when they'd rather leave because the Russians impose too many hurdles to leaving? So it's we could probably have a whole podcast on the exit tax, but not enough time today to do that. So why don't we turn to the last issue that we're going to talk about today, and we're not going to have enough time to really get deeply into that issue either. But one of the things that I think the Russian sanctions have not caused, but they have exemplified, is this convergence between sanctions and export controls. For a long time under U.S. law, and I think under EU as well, there was a sanctions authority, and sanctions were mostly financial, but when it came to goods, manufactured goods and other items, those were mainly the province of export controls. And at least on the U.S. side, OFAC in the Treasury Department controls sanctions, and BIS in the Commerce Department controlled export controls. And until recently, I'd say the last 2 or 3 years, it was like they didn't really talk to each other that much. I mean, there's been growing coordination before that, but from the U.S. side, the last 2 or 3 years has been this kind of rise of export controls as a sanctions tool. So why don't you both talk about that? We'll start with Laura on the EU side, and then we'll turn it over to Caroline on the U.S. side.
Yeah, I mean, the good thing is in Germany, the export control authority is the same that deals with the sanctions regulations, at least on the products. On the financial sanctions, asset freeze, we have the Central Bank of Germany, the German Bundesbank. But on the product side, you have the BAFA, which is basically the same for Russian sanctions and for export control sanctions, for export control regulations and sanctions regulations. But we do see like a mixture of the two regulations now. I mean, in the Russian sanctions regulation, you would see that they refer to the dual use regulation, which is an export control regulation. So saying any dual use goods are not allowed to go to Russia. Then you have products that have not been categorized as critical in the past. So because they're not dual use products, or they're not as critical, as we needed them to be in order to get listed. So they have had all these annexes. I think in total there are like 30 annexes in the Russian sanctions regulations, basically just listing all these products that are not allowed to go to Russia, which I think you would say they're not on they're on the commercial list, and for us they just weren't on any list. And they have been doing this with the customs codes, which has led to all these issues between customs understanding, custom regulations understanding, and sanctions regulation understanding. But I think that's another topic as well. But yeah, they have expanded the lists and have had a bundle of export control restrictions, sanctions restrictions, and so on, that you don't really keep them apart anymore, at least what Russia is concerned.
Interesting. Well, Caroline, why don't you talk a little bit about from the U.S. side? It does sound like there's a bit of similarity in the sense that we do have BIS that deals with goods from the export control side, and now mostly administers the export controls that look a lot like sanctions. But OFAC has a role to play on services, on financial services in particular, but also on a bunch of other transactions. And OFAC is the one that actually puts people on the list.
I definitely agree that it's been a very unique situation where the use of the export controls as a tool has been very uniquely matched to the imposition of the economic sanctions by OFAC. Since 2022, in the beginning, we've seen the sanctions ramp up in order to exert more pressure. And I think the export controls on the Russia side have reflected that similar approach. They started at one level and they have increased and evolved since that time, and may continue to do so. And I think that that's the sign of the coordination between OFAC and BIS in the U.S. But I think there's also I forgot to mention that I think this is an area where the U.S. and the EU have also had some coordination, is on how to impose these kinds of export controls to prevent the flow of technology to Russia, particularly technology that's seen as a threat. And in the U.S. export controls, at least, there are some references to allied countries, the EU countries, where we say, U.S. export controls are not going to apply in this situation when they're controlled by another authority. We leave it to them. And that's something that's fairly unique under the U.S. regulations. Usually export controls just apply. And so you can see that level of coordination there. It's unprecedented. With regard to kind of the level of U.S. export controls, they started a little lesser in 2022 in the beginning, and they've ramped up now to cover so many items, generally every item that's on the commerce control list. And then now it's expanded to a number of items that are even beyond that, similar to the EU. And it's also being that list of items is being described using customs codes because there's no other codes to use. There's no export control numbers for these items. The list is currently at like 67 pages, I think, and that's like well over 1,000 items, including some consumer type products. And so it's definitely a challenge. It's a situation where there's not a complete embargo on exports to Russia, unlike some countries subject to U.S. export controls. But it is very difficult to determine, is your product restricted for export to Russia, or even situations where U.S. export controls are more extraterritorial in covering foreign-made items that have U.S. content. The rules there have also been changed to become very complicated for Russia and incorporate a lot more items that otherwise wouldn't be subject to U.S. export controls.
Yeah, the one thing that has kind of been a part of the increased use of export controls is that the BIS from the U.S. side is incorporating these sorts of import principles. So customs harmonized tariff codes, the doctrine of country of origin and substantial transformation. All of this stuff is import law. Like I thought I was never going to have to learn import law. I'm an export lawyer. That's Richard Mojica's field. But now, you really do have to brush up on your harmonized tariff codes. I'm assuming it's the same from the EU side as well. That's how these restrictions are being categorized. Is that right, Laura?
Yeah, exactly. It's categorized by the European Customs Code, which I think is basically what you call import law.
Yep.
So yeah, and this has so suddenly companies who have just been dealing with customs law, they now have to learn sanctions law, and companies who have just been dealing with export control and sanctions law, now they have to learn customs law. So and the same goes for the lawyers.
That's right. It's a brave new world.
Yeah, and then and when we had the luxury good list, it was so extensive that we were wondering how this happened. There were like wicks and rubber boats on it, and we're like, is this really so important for Russia that we have to sanction it? But there was a rumor that basically the EU legislator just copy pasted the North Korean sanctions list. So there were like, several hundred items on it that weren't that relevant for Russia, but it just had to be fast. So we just copy pasted another regulation.
You've already got a luxury good list laying around. You might as well use it. Just reuse it. Well, I think we're going to leave it here. So, Laura, thank you for coming on the podcast. Really enjoyed talking with you.
It was a pleasure.
And Caroline, thank you.
Thank you so much.
And thank you for listening, everyone. And stay sanctions free.
Produced by Heartcast Media.